another one against the Trinidad and Tobago.
Mr. Knox.
My Lords, in this matter, I appear on behalf of the first and second appellants, together with Mr. Robert Strang and Mr. Stefan Ramkisoon, and Mr. Ramesh Maharaj, Senior Counsel, together with Dinesh Rambali, Kiel Kalkal Singh, and Mr. Ria Khan, appear for the second appellant at Central Broadcasting. I should say that Mr. Vijay Maharaj, who is the first appellant, is present in court. As for the respondents, they are represented by Mr. Fayad Hussain, Senior Counsel, Mr. Rishi Das, Senior Counsel, and Vanessa Gopal. My Lords, it's been agreed that the appellant should have until 12:40 p.m. for their opening.
Yes.
I will take 2 hours, and then Mr. Ramesh Maharaj will say some things in particular relevant to the local circumstances in Trinidad. My Lords, you will see there are two main questions that arise in this appeal. Are sections 3 and 4 of the Sedition Act unconstitutional because they infringe section 1 of the Constitution? That is to say, the guarantee, as we say, that Trinidad shall be a sovereign democratic state. Second, in any event, are they unconstitutional because they breach sections 4 and 5 of the Constitution and are not saved as an existing law by section 6. Those are the two main issues. My Lords, I propose to structure my submissions as follows. I'm going to say a few points, just a few points on the facts. Then I propose to say something about the common law of sedition and comments that have been made at a high level about sedition laws around the world. Then I will go to the background of the Trinidad Sedition Act, which was passed in 1920. Then I shall go to the Sedition Act itself. I'll take you through that and the various amendments made to it in 1971 and 1976. I'll then go to my first submission about sovereign democratic state, and then to my second submission. My Lords, just on the facts, I don't propose to go to the speech in question, but I should just summarise, if I may, what the background to it was and what Mr. Maharaj was saying. Mr. Maharaj was the founder of Central Broadcasting Services and quite a controversial figure, very critical of politicians, made his own talk show on the radio, and critical of the government and its policies. In particular, he was a secessionist, a bit like the Northern League, as it were. He believed that Trinidad and Tobago should be separate, and that Trinidad should no longer be they should no longer be part of the same state, and that that Tobago was a drain on Trinidad's resources. That was his fundamental point, and he'd made that point quite a few times. And that is the background to the statement. And on the 9th of April, he made statements on his talk show, The Mahasabha Strikes Back. And the gist of them was that Trinidad should no longer subsidise the daily ferry which took people from Tobago to Trinidad, because it was a waste of money, as the people from Tobago who came over on the ferry didn't add anything to the economy. And in the course of doing this, he said that all Tobagonians do is loaf around, playing on the beach and raping white women. He also criticised Mr. Fitzgerald Hines, who was a minister who worked in the Attorney General's office, who had a Rasta haircut because Mr. Hines had criticised Miss Haddad, who was the leader in the Tobago Chamber of Commerce. And that's the background. And for this, the Central Broadcasting Limited was censured by the Telecommunications Authority on the 17th of April 2019. They criticised him on the basis that his comments were divisive and insightful, but the licence wasn't withdrawn. It hardly be said there are terms on which the licenser is held. And the following day, Central Broadcasting's premises were searched by 9 police officers on the 18th of April 2019, and then again subsequently by 10 officers on 13th of June 2019. If I can just give you the references for that. It's page 407, paragraph 10, and page 410, paragraph 15. And what they were looking for was the originals or tapes of the actual broadcast. The warrants, the search warrants, if I can just show you these, are at pages 503 and 507. The reason I do so is because they don't identify any particular section under the Sedition Act under which they had been issued by the magistrate. So if you go to page 503, you'll see the first of the warrants. And the relevant bit is near the end of the first main paragraph, in the last 3 lines, for which there is reasonable grounds for believing may afford evidence at the commission of indictable offences under the Sedition Act are concealed in the premises. So there's no reference to which section is being relied on, or subsection is being relied on. And likewise, to similar effect at page 50, I think it's 507. And these were issued pursuant to applications on the previous, which are on the previous pages. On the 31st of May, Mr. Satnarayan Maharaj and the Central Broadcasting issued these proceedings to restrain him being prosecuted, or them being prosecuted, under the Sedition Act. But Mr. Maharaj then died in November 2019. Proceedings were allowed to continue in the name of his son in his place, together with the Central Broadcasting Authority. It is to be noted that although at first instance the court held that the court could grant a declaration in favour of the claimant in the public interest, I give you the reference, page 317, paras 23 to 27, nonetheless the Court of Appeal upheld the decision that the first claimant could be substituted, and that is at page 939, paragraph 31. They held that on the proper construction of the civil procedure rules, the person, Mr. Vijay Maharaj, who was now the first appellant, could be joined to the action and had a sufficient interest in doing so. Now, my lords, the common law about sedition. We deal with this in paragraphs 17 to 24 of our case. Perhaps the simplest place to start is with the Law Commission working paper, which one sees at page 3506 of the record. And what's the date of that? I think it's 19... Oh, my lord, I'll have to... my lord, I think if I go there, I can find it. I can't remember off the top of my head. Yes, I do apologise. This is 1977, Mr. Strang tells me, and 3506 is the part of the paper which deals with sedition. And at this time, sedition was still a common law offence in England and Wales. And you can see in 3506, introduction, there's probably no offence properly described as sedition in English law. But the oral or written publication of words with a seditious intention and an agreement to further seditious intention by doing any act have always been common law offences. As with many common law offences, when one penetrates back in history beyond the 19th century textbook formulations, one finds a confusing lack of differentiation between various offences. In the case of crimes of sedition, one also finds that prosecutions were usually brought with overtly political motives. For our purpose, which is to consider what place, if any, crimes of sedition should occupy in a modern criminal code, we think it's sufficient to start with the definition of seditious intention proposed by Sir James Stephen in his digest. My lords, I do want to take you to this. So, para 69, Stephen's definition of seditious intention was accepted as accurate by the Criminal Code Commissioners and by Mr. Justice Cave in his direction to the jury in R.B. Burns. And then, my lords, if I can just ask you to read over the page, 3507, Article 114 in Stephen's Digest of the Criminal Law, my lord, which was, I think I'm right in saying, printed in 1888. And my lords, it is worth looking at this because these are obviously form the basis of the Sedition Act of 1920. And, my lords, you'll see it has quite a number of components. But broadly, very broadly, one might be able to break it down into a seditious intention to bring into hatred His Majesty, is one, and then there's the church or state by law established, or to raise discontent or disaffection amongst His Majesty's subjects, is the next limb, and then finally, slightly out on a limb, or to promote feelings of ill will and hostility between different classes of such subjects. All the rest seem more aimed at the state or arms of the state, but that last limb appears to be more just people amongst themselves. And then you have the exception. And then one follows at 3507, intention to cause violence. It is clear that there is a qualification to the rules as stated by Stephen. It is not sufficient merely to show that the words were used with the intention of achieving one of the objects set out in Article 114. It must also be proved that there was an intention to cause violence. Reference is then made to certain cases from the 19th century. Indeed, Stephen himself, in his History of the Criminal Law of England, accepts that nothing short of direct incitement to disorder and violence is a seditious libel. The reference is then given. He states that the modern view of the law is plainly and fully set out by Mr. Justice Littledale in Collins. And they then go on to discuss what that said to similar effect. And then B, intention to disturb constituted authority. The most careful analysis, which has been given to the law of sedition in recent years, is in the judgment of the Supreme Court of Canada in Boucher. The court held that the seditious intention upon which a prosecution for the seditious libel must be founded is an intention to incite violence or to create public disturbance or disorder against His Majesty or the institutions of government. Proof of an intention to promote feelings of ill will and hostility between different classes of subjects does not count alone, so it does not alone establish a seditious intention. Not only must there be proof of incitement to violence in this connection, but it must be violence or defiance for the purpose of disturbing constituted authority. Subject of the charge in this case was a pamphlet issued by a group of Jehovah's Witnesses attacking the police, public officials, and the Roman Catholic clergy, on the grounds that they persecuted members of the sect and alleging that the clergy unjustifiably influenced the courts and the administration of justice. My Lord, can I just go, just to give a little bit more context, go to Boucher? It's an important judgment. The problem arose because seditious intention was given a fairly loose definition.
Mr. Knox, I'm afraid we've got a technical problem. We're going to have to rise for a few moments so they can be corrected.
Yes.
I'm very sorry. Mr. Knox.
Yes, my lords, I was going to go to Boucher just to flesh out a little what is said in relation to certain parts of the definition. This is a little bit more nuanced, actually, than one sees in the Law Commission report. My lord, first of all, if I can go to the judgment of Mr. Justice Kirwan, I should say it was a 6-3 split decision, I think.
Page?
But, at 1901.
And is this the Supreme Court addressing the common law effect?
Yes. Well, it's not addressing the common law. The actual statute, my lord, forgive me, I did have a reference to it. It was incorporated by a statute which had only a relatively limited definition of intention. My lord, if I can be forgiven, if I can come back to that in a moment. The actual definition of intention is, I think, set out in, if you go to 1893, there was a statute about sedition, at 1893, second paragraph down, there was a definition, or rather a rather loose attempt at a definition of intention. Then if we turn to section 133A, also in force when the present appellant was proven to have distributed a seditious libel, the legislature there indicated certain cases where one would not be deemed to have had a seditious intention only because he intends in good faith to point out, in order to their removal, matters which are producing or have a tendency to produce. My lords, that's part of the definition. My lord, I do apologise. If I can come back to my lord, here we are, 1896. This is the relevant part of the criminal code in Canada. And you can see halfway down 1896 to the end of the page, the definition. My lords, perhaps I can just ask you to look at that.
Section 133.
1896. Section 133.
Yes.
So, my lords, you'll see there's a very general definition of sedition in 133 itself, which doesn't tell you very much about what is meant by seditious intention, except what you see in section 4. And then you have, evidently superimposed by a later amendment, Stephen's exception in 133A. But there was no definition of intent, of seditious intent in the Act, and that's made clear over the page in 1897, about 6 lines down by Mr. Justice Kirwan. And the question arose, was this: was the effect of the Canadian Criminal Code such as to require the prosecution only to show the things you expressly see in section 133 and 133A, or did the prosecution also have to show an intention to incite violence or not? And the argument for the appellant was that that was implicit because that was always the common law position, and that was the position that was accepted by the majority of the Supreme Court. And so on that basis, they held that there was no way in which it could be said that the appellant could be said by his publication to have intended to cause violence, and on that basis, they allowed the appeal and refused to remit it to be reassessed. And you can see the arguments which prevailed. First of all, 1901, in the judgment at the top of the page, in the judgment of Mr. Justice Kirwan, it might say, when you get to page 1901 at the top of the page, Tascaro J. In fact, that's misleading, because his judgment was a dissenting judgment which begins halfway down the page. It's still Mr. Justice Kirwan at the top of the page. And he says the intention on the part of the accused, which is necessary to constitute seditious libel, must be to incite the people to violence against constituted authority or to create a public disturbance or disorder. What is stated previously, that the question is, was the language used calculated to promote public disorder or physical force or violence? There should be added that the public disorder or physical force or violence must be against established authority. An intention to bring the administration of justice into hatred or contempt or exert disaffection against it is not seditious unless there is also the intention to incite people to violence against it. So far as the decision in McHugh is in conflict with this, it should not be followed. So that is one approach that was taken by Mr. Justice Kirwan, and you'll see there he talks about administration of justice and the intention to cause violence in relation to administration of justice. Mr. Justice Kellogg, at 1918, again in the majority,
I'm so sorry, I missed the page number.
1918.
Thank you.
He here is talking about the intention required for sedition in relation to stirring up disaffection amongst different classes. And he, at the foot of page 1918, having reviewed the authorities, says this: the actual subject matter of the trial before Mr. Justice Cave, therefore, was not simply an indictment charging words spoken, tending to create ill will between classes of subjects implicita, but incitement of such ill will inter alia, all directed against government. And then, in my opinion, there is a great distinction between the subject matter of Burns's case and that of Leese's case. It cannot be that words which, for example, are intended to create ill will, even to the extent of violence, between any two of the innumerable groups into which society is divided, can, without more, be seditious. In my opinion, to render the intention seditious, there must be an intention to incite to violence, or resistance, or defiance for the purpose of disturbing constituted authority. I do not think there is any basis in the authorities for defining the crime on any lower basis. And then, at 1921, again in the same judgment, Mr. Justice Kellogg turns to the requirement or the mens rea if you are accused of disturbing the administration of justice. And the last paragraph in 1921, at the present time, therefore, in England, matter of the character here in question, if made the subject of criminal process at all, appears to be treated as contempt of court rather than seditious libel. Such matter may, of course, be regarded from the standpoint of seditious libel if intention of the necessary character be established. The definition set forward in Halsbury's laws, so far as relevant, the subject is a seditious intention is intention to bring into hatred or contempt or to excite disaffection against the administration of justice. And he adds, to which I would venture to add the end and purpose being to defeat its functioning. And then he goes on to discuss a case from the 19th century, I think. And then he continues, in considering this aspect of the matter, it is essential in the present case to keep in the forefront of one's mind what has already been said as to the burden of the pamphlet, and the pamphlet should be read as a whole. It doesn't speak generally of the administration of justice in the province, nor of the courts generally, and the references to the courts are bracketed with references to local legislative bodies. So, my lord, it does seem in relation to the administration of justice that you don't necessarily have to show an intention to create violence, but certainly at least an intention to prevent justice, just the end of justice being achieved. And then at 1925, in the judgment of Mr. Justice Esty, there's another reference to the mens rea required for sedition in relation to stirring up disaffection between different classes. At 1925, at the foot of 1925, Mr. Justice Esty turns to the judgment of Mr. Justice Cave in Burns, and the ill will and hostility between different classes of His Majesty's subjects. This vague and general character is further emphasised in the law of the Constitution, Dicey, where after pointing out that the law permits publication of statements indicating that the Crown has been misled, or that the government has committed errors, and in short sanctions criticism of public affairs, which is bona fide intended to recommend the reform of existing institutions by legal methods, the learned author, this is Dicey, concludes, but anyone will see, and my lords, I rely on this quite generally, but anyone will see at a glance that the legal definition of a seditious libel might easily be so used as to check a great deal of what is ordinarily considered allowable discussion, and would, if rigidly enforced, be inconsistent with prevailing forms of political agitation. And then, over the page, 1926, the foregoing emphasises the importance of intention and the necessity of a trial judge explaining to a jury, in such cases here, the meaning of intention to promote feelings of ill will and hostility between different classes of His Majesty's subjects as an essential in the offence of sedition. And then he goes on to refer to other cases, and then at the foot of the page, about 5 lines up, the essential without which there cannot be sedition is the presence of a seditious intention as above defined, and which is a fact to be determined in each case. And then finally, I think in the judgment of Mr. Justice Locke, is a long judgment and a very, very detailed exposition of the history. First of all, at 1935.
Sorry, page?
1935.
Thank you.
And here he is talking at the foot of the page, he's talking about the administration of justice. And one can pick that up from the penultimate paragraph. A seditious intention is an intention to bring into hatred or contempt or to excite disaffection against the administration of justice. The matters are stated disjunctively. The words used are hatred or contempt against the administration of justice, which must necessarily, I think, include the manner of its administration by individual judges or others discharging judicial functions. Assuming this and the accuracy of the definition, in my opinion, the first three of the quotations from the pamphlet without more afford evidence proper to be submitted to a jury of an intention to excite contempt or hatred of individuals referred to, or of the manner in which justice has been administered by them. If, on the other hand, Stephen's definition should be added with the intention of inciting resistance to or disobedience of the law or the authority of the state, which I think more correctly defines the offence, then I think the pamphlet affords no evidence. And my lords, to similar effect, in 1942, in the same judgment, at the foot of the page, having discussed further cases, I think some Irish cases, 4 lines up from the end, since these statements were made and charged to a grand jury, the learned judge did not refer to the authorities, and there is thus no indication as to what he relied on to support his statement last referred to. My own view is that he intended by his last remark to be read in conjunction with what he had said earlier, and accordingly meant that to endeavour to promote public disorder or defiance of the law by bringing the administration of justice into contempt or seditious conduct. If he didn't mean this, I think with respect the statement was inaccurate. So it's not just a matter of violence. In relation to the administration of justice, it's more encouraging defiance of the law. And so that's why I mentioned that. But, my lords, this is something which the Supreme Court is a very detailed judgment, and I submit that one thing that comes across quite clearly is that the common law required more than merely saying something that was likely to cause hatred or disaffection. There had to be an intention to create disorder or violence, or in the case of the courts, defiance to proper authority, lawful authority. My lords, there is a short summary of the sedition laws in the United Kingdom, the United States, Canada and Australia in a recent report prepared by the Law Commission in India in May 2023. That report was prepared because a case had gone up on the equivalent to sedition in India, had gone up to the Supreme Court. And what the Supreme Court said is, well, we're going to put a stay on any further prosecutions, but we'd like the Law Commission to report to us about what's going on and what they think about the law of sedition. And therefore, the Law Commission, in fairly short order, produced a fairly learned note about the law on sedition, and you can find at supplementary authorities, our supplementary authorities, pages 376 to 388, a short resume of the 376 to 388, a short resume of the law of sedition in the 4 countries I've mentioned. In broad terms, the sedition laws in those countries have been repealed and replaced with laws or other laws which make it plain that an intention to incite violence or public disorder is a necessary ingredient of whatever crime has now replaced the previous sedition law crime. My lords, I mentioned that to you. It's not mentioned in our case because it only came out on the 25th of May, but it's a useful resume of the differences. I should say this. Of course, the sedition law in India has been, unlike most other places, I suspect, has been much used recently, and this is why it's a matter of such great importance in India. But what the Law Commission did was effectively say that there was no harm in a sedition law which had the qualifications which I've just mentioned, but otherwise it would be unconstitutional in the sense that it would be an unjustifiable restriction on freedom of speech. I will come to that briefly later, but that's the thrust of it. My lords, in paragraphs, I should also add, in paragraphs 109 to 111 of our written case, we refer to decisions of the courts in Uganda, Tanzania and the Gambia, in all of which, essentially, sedition laws have been struck down on the basis of vagueness, and in particular, because they don't require an incitement to violence or public disorder. That's Uganda, Tanzania, and the Gambia. I would particularly, though, like just to take you to a couple of authorities, one from the United States and another from Canada, which make plain what I submit is the odious nature of sedition laws unless they have some qualification along the lines that I've mentioned and upheld in Boucher. The first is a decision of Mr. Justice Brennan in the United States Supreme Court, I think in the early 60s or maybe late 50s, called Sullivan, and that is at page 103 of our supplementary authority bundle. The decision, I think the case actually begins at 85, but Mr. Justice Brennan discusses the history of freedom of speech in the United States, and you can pick it up in particular at 103, because there was in 1798 a Sedition Act passed in the United States. And one can pick it up from the last paragraph. This is the
which page? Sorry. Which page, please?
103 of the supplementary authority. In the last paragraph, 4 lines down, this is the lesson to be drawn from the great controversy over the Sedition Act of 1798, which first crystallized the national awareness of the central meaning of the First Amendment. Reference is then given. The statute made it a crime, punishable by a $5,000 fine and 5 years in prison, if any person shall write, print, utter, or publish any false, scandalous, and malicious writing or writings against the government of the United States or either House of the Congress, or the President, with intent to defame or to bring them or either of them into contempt or disrepute, or to excite against them or either of any of them the hatred of the good people of the United States. The Act allowed the defendant the defence of truth and provided that the jury were to be judges both of the law and facts. Despite these qualifications, the Act was vigorously condemned as unconstitutional in an attack joined by Jefferson and Madison. In the famous Virginia resolutions of 1798, the General Assembly of Virginia resolved that it doth particularly protest against the palpable and alarming infractions of the Constitution in the 2 late cases, which are then mentioned, the Sedition Act exercise of power not delegated by the Constitution, but on the contrary expressly and positively forbidden by one of the amendments, a power which, more than any other, ought to produce universal alarm because it is levelled against the right of freely examining public characters and measures and of free communication among the people thereon, which has ever been justly deemed the only effectual guardian of every other right. And of course we echo that, and we say that is the fundamental objection to the 1920 Act, which I shall come on to later. Madison prepared the report in support of the protest. His premise was that the Constitution created a form of government under which the people, not the government, possessed the absolute sovereignty. The structure of the government dispersed power in reflection of the people's distrust of concentrated power and of power itself at all levels. This government, it says, form of government was altogether different from the British form, under which the Crown was sovereign and the people were subjects. Is it not natural and necessary under such different circumstances, he asked, that a different degree of freedom in the use of the press should be contemplated? And so the matter continues. And my lords, I emphasise that because one of our points, of course, will you've seen, is that the 1920 Sedition Act in Trinidad was indeed passed at a time when Trinidad was a colony, and what is more, without an elected legislature. There was simply a governor who was appointed by the Crown, and I think there were 20 members of the Assembly, and they would pass the laws, the relevant laws. I should say, just while I'm on this point...
Sorry, were they elected?
No, they were not elected. They were chosen by the governor, and the governor was himself appointed by the Crown. There was elections for property owners, as I understand it, first introduced in 1925, and it was only in 1947 that there was a full franchise. But I do emphasise that there is a difference in mentality, if I can put it this way, between a country which is a sovereign democratic state, where the people, so to speak, are sovereign, and a country where the Crown is sovereign, and not just as a matter of what you might call theory, but in actual fact, as was the case in 1920 in Trinidad. My Lord, my learned friend Mr. Strang, on this point about the importance of freedom of speech in a democracy, also draws my attention to the foot of page 105, if I may go to that. The report on the Virginia resolutions further stated, it is manifestly impossible to punish the intent to bring those who administer the government into disrepute or contempt without striking at the right of freely discussing public characters and measures, which again is equivalent to a protection of those who administer the government, if they should at any time deserve the contempt of hatred of the people against being exposed to it by free animadversions on their characters and conduct. Nor can there be a doubt that a government thus entrenched in penal statutes against the just and natural effects of culpable administration will easily evade the responsibility which is essential to the faithful discharge of its duty. My Lord, in the event, as I understand it, I think we referred to this in one of our Britain cases below, the Sedition Act came to an end, I think a few years later, and those who had been convicted on it were pardoned. So all was well in the end. My Lord, the position in Canada, can I take you to that? This isn't a Sedition Act case, but this is a case where a law was passed which made it unlawful to have communist publications in one's house, and someone therefore lost his tenancy as a result. He was thrown out because he had some communist publications, as it was said. And the matter went up to the Supreme Court, and there were a number of issues, but one of the issues was, well, was this even a law which could possibly be contemplated in a democracy? And if I can ask you please to go to 3223. The case is Spritzman and Eibling. And this is judgment of Mr. Justice Rand, indicated by the opening words of the preamble in the Act of 1867, reciting the desire of the four provinces to be united in a federal union with a constitution similar in principle to that of the United Kingdom. The political theory which the Act embodies is that of parliamentary government, with all its social implications, and the provisions of the statute elaborate that principle in the institutional apparatus which they create. Whatever the deficiencies in its workings, Canadian government is in substance the will of the majority expressed directly or indirectly through popular assemblies. This means ultimately government by the free opinion of an open society, the effectiveness of which, as events have not infrequently demonstrated, is undoubted. But public opinion, in order to meet such a responsibility, demands the condition of a virtually unobstructed access to and diffusion of ideas, and I particularly emphasise that. Parliamentary government postulates a capacity of men acting freely and under self-restraint to govern themselves, and that advance is best served in the degree achieved of individual liberation from subjective as well as objective shackles. Under that government, the freedom of discussion in Canada as a subject matter of legislation has a unity of interest and significance extending to every part of the Dominion. With such dimensions, it is ipso facto excluded from Head 16 as a local matter. And that's a point that doesn't matter. The constitutional fact is the political expression of the primary condition of social life, thought, and its communication by language. Liberty in this is little less vital to man's mind and spirit than breathing is to his physical existence. As such an inherence in the individual, it is embodied in his status of citizenship. Outlawry, for example, divesting citizen standing and destroying citizenship is a matter of Dominion concern, and so forth. My Lords, again, we echo those sentiments. We also refer in our case to what you can see, I'll give you a reference to it, at 3243 in the judgment of Mr. Justice Abbott. I think the long and short of this decision was that the local legislature had no business in any event to be passing a law which prohibited or made it a criminal offence, which prohibited the possession of communist publications. But these were further points they made in addition. Now, my Lord, I come to the position of Trinidad and Tobago. As I've said, the law was introduced in or the ordinance rather was introduced in 1920, and there were no elected officials at the time. There appear to have been about a legislative assembly of about 20 people, and one can see that in practice at page 1033. I don't propose to go there. You can actually see who voted on the resolutions in relation to the ordinance. There are about 20 people or so. Now, the reasons for the introduction of the 1920 law are set out briefly by Mr. Justice Seepersad in his judgment at first instance at page 345 at paragraphs 86 to 87. And if I can ask my lord just to look at that.
Page again, please.
Yes, page 345.
Thank you.
Paragraphs 86 to 89. As the top of 345, when one considers the historical backdrop against which the codification of the common law of sedition occurred, it is possible to conclude that the primary intent behind sedition laws was to protect the interests of those who governed in the colonial era. In 1919, dock, railway and utility workers protested against a backdrop of racism and low wages. There was a turbulent period of labour riots, and in 1920 the Sedition Act was passed. The Act sought to clamp down on speech and publications which posed a threat to colonial order. The banned Calypsonian King Radio wrote that they want license we mouth, they don't want we talk. Under the codified sedition law, Labour hero Uriah Buzz Butler, who fought for the rights of workers, was prosecuted, convicted and jailed. And then in 1989, I may as well continue. After independence in 1962, political power became more accessible, but the pre-existing colonial systems, institutions, educational framework and laws endured. The relative unchanged nature of the status quo restricted the formation of a truly independent state. Independence requires independence of thought and a willingness to forge a truly free and regulated society, which operates within the boundaries defined by the Constitution. My lords, one can see the Sedition Act as originally passed at page 3438. And you can see section, after the various definitions, at section 2, but perhaps I should just take the preamble. Forgive me, my lords. An ordinance to provide for the punishment of seditious acts and seditious libel, to facilitate the suppression of seditious publications, and to provide for the temporary suspension of newspapers containing seditious matter. And then section 3, a seditious intention is an intention A, to bring into hatred or contempt, or to excite disaffection against the person of His Majesty, or the government and constitution of the United Kingdom, or the colony, or any other British possession or protectorate as by law established, or either House of Parliament, or the executive or legislative councils, or the administration of justice. B, to excite His Majesty's subjects to attempt, otherwise than by lawful means, to procure the alteration of any matter in the state by law established. C, to raise discontent or disaffection amongst His Majesty's subjects. Or D, to promote feelings of ill will and hostility between different classes or races of such subjects. So very similar to the formulation by Mr. Justice Stephen. I think I'm right in saying that the addition is, there's an addition there, all races of such subjects. I don't think, my lord, that appears in Mr. Justice Stephen's definition. And then the limitation is, again, my lord, in very similar terms to what was set out by Mr. Justice Stephen in his definition of the common law. And my lord, perhaps I can just ask you to read that yourself. So the mere, if you are intending to correct error, then that of itself isn't going to mean that you have a seditious intention. I'll come back to a proper construction of these sections later. And then subsection 3, in determining whether the intention with which any act was done, any words were spoken, or any document was published, was or was not seditious, every person must be deemed to intend the consequences which would naturally follow from his conduct at the time and under the circumstances in which he so conducted himself. My Lords, I should say, of course, that although now one would regard that perhaps as a rather stringent and unfortunate law, of course, at that time, the criminal law being what it was, that was not an unusual definition of intention, because you couldn't go into the witness box to give evidence yourself. Perhaps by 1920 you could. But the general idea was, therefore, you're presumed to have intended the natural consequence of your act. Therefore, that was sufficient for intention. But I will come back to that section later and say why it makes this law all the worse. One then goes to amendments that were made in 1971. These are at 3428. And, my Lords, I don't propose to run through them in this section. They begin at 3428. And this was an act passed under the 1962 Constitution with a special majority, as provided for by section 5.2, and you can pick that up at 3428, and whereas it is provided by subsection 2 of the said section 5 of the Constitution that an act of Parliament to which that section applies is one the bill for which has been passed by both Houses of Parliament and at the final vote thereon in each House has been supported by the votes of not less than 3/5 of all members of that House, and whereas it's necessary and expedient.
So that was on the basis that it was a pre-existing law?
Well, no, at this point, the Section 5 fulfilled the same function as Section 13 of the 1976 Constitution, which allowed Parliament, by a 3/5 majority, to pass a law which infringed or derogated from the fundamental rights and freedoms, as long as it was reasonably justifiable in a democratic society. So this is under that provision, Section 5, that this law was passed in 1971. In other words, to make sure that the amendments could not be objected to unless they were not reasonably justifiable in a democratic society. That was the purpose.
There was an existing law provision also in the 1962 Constitution.
There certainly was one, yes. The purpose, sorry.
So the 1920 legislation was an existing law, and it was then amended under an enhanced majority.
Yes, to beef it up in certain ways.
Yeah. Right.
My Lords, we refer to this in our case, but can
sorry, you say beef it up, and wasn't it to make it more appropriate to Trinidad and Tobago, which by this stage was a republic, wasn't it?
No, it wasn't, my Lord. No, this is in 1971. And the effect of this, in very broad terms, was to expand on Section 3.1d in a way I'll show you in a moment, and to introduce a Section 3.1e, which said which included amongst the seditious intentions an intention to cause destruction of groups or genocide. Not now, you might ask, why on earth did they do that? And that is because in, I think, the early 1970s there had been a revolution in Trinidad. And in 1971, we refer to this in one of our notes in our case. In 1971, in the elections in 1971, all the major opposition parties boycotted the elections, and so there was only one party who had any seats at all, which was the PNM. They had all 36 seats. And therefore, they were obviously in pole position. They could, in one sense, pass whatever laws they liked. The effect was also, I should add this, the effect of this amendment was, first, to make alterations to Section 3, along the lines I've just mentioned. Secondly, to give the police a power of search. And thirdly, to increase the maximum sentence from 2 years to 5 years. And my Lords, at 3430, Section 4, Section 3 of the ordinance is amended as follows. In subsection 1, by deleting the words occurring after the words "or to excite disaffection against," and then just to alter the words "the government or constitution by law." So in other words, there was simply what you might call formulaic alterations to remove references to His Majesty and change them for government or constitution. Likewise in subparagraph 2, section 4, and likewise subsection 3. And then, my lords, a new subsection 3(1)(d) was introduced, and you can see it's an expansion of the previous, rather simplified version. E, to engender or promote feelings of ill will or hostility between one or more sections of the community on the one hand, and any other section or sections of the community on the other, and was perhaps not so different as before, or 2, feelings of ill will towards, hostility to, or contempt for any class of inhabitants of Trinidad and Tobago distinguished by race, colour, religion, profession, calling, or employment. That's a new alteration to D. And then 5, by adding the following new paragraph, E, to advocate or promote with intent to destroy in whole or in part any identifiable group, the commission of any of the following acts, namely killing members of the group, deliberately inflicting on the group conditions of life calculated to bring about its physical destruction. And there are various other amendments, my lord, which I don't think have any particular significance, apart from what I mentioned about the right to a police search. My lord, the final version, therefore, the relevant version of the Act is what you now see. I think it's 3406. And if I can ask you to go to 3406, or starting at 3406, but page 3410, you can see the Sedition Act in its form. I should mention, in 1976, alterations were made to change Attorney General to Director of Public Prosecutions, but those are, again, entirely formal alterations. But what you see at 3410 is section 3. 31A is in much the same form as it was originally, except changing His Majesty and references to subjects and so forth, and to a rather simplified version, bring into hatred or to excite disaffection against the government or the Constitution as by law established, or the House of Representatives, or the Senate, or the Administration of Justice. B, to excite any person to attempt to otherwise than by lawful means to procure the alteration of any matter in the state by law established. C, to raise discontent or disaffection amongst the inhabitants of Trinidad and Tobago. And then D, 1 and 2, in the forms you've just seen. And then E, in the form you have just seen. And subsection 2 is in all material respects the same as it was originally, but replacing references to His Majesty and so on with the government.
And when was this Act passed?
This Act is exactly the same. It's the It was the Act as passed in 1920, as amended in 1971 by the amendments I've shown you, and as again amended again in 1976 to replace, I think, the word Attorney General, which was in the previous Sedition Act or Ordinance, with Director of Public Prosecutions. But in all other respects, the 1976 amendment did nothing. So the material amendment was made in 1971. 1976 simply made a consequential amendment to change Attorney General to Director of Public Prosecutions. And, my lords, for today's purposes, we are concerned with sections 3, 1 and 2. And, my lords, I now come to my first submission. And I say sections 341A to D, as read together with section 4 of the Act, taken as a whole, are inconsistent with section 1 of the Constitution, both with the word sovereign, or the adjective sovereign, and with the adjective democratic. My lords, I do say this, even if in the alternative, section 3, I should say this, I don't contend that section 3(1)(e), which is the genocide provision, is inconsistent with the notion of a sovereign democratic state. But I do, that's my main submission, therefore, is 3(1)(a) to D, and for taken as a whole inconsistent. I have an alternative submission, even if section 3(1)(b) and part of D2 on their own could be justified in part, it would not be right to sever them from the rest of the Act, or the rest of Section 3. The whole of it has to go. I'll elaborate my submissions in a moment. And the reason why I say these provisions are inconsistent with the guarantee of democracy, or a sovereign democratic state in Section 1, is simple. These provisions have a chilling effect on freedom of speech and the right to criticise, A, those in politics and public life, and B, powerful interest groups who play an important role in the functioning of democracy. And I say the matter is all the worse because of the deeming provision. You are liable even if you did not intend any such thing to happen. And I say the qualification, which you see in Section 3.2, just staying at page 3.4.10, does not make the matter substantially better. And if I can just say what I say the problem with Section 3.2 is, my lords, it allows for this. It allows for a defence when I can say, well, I intended to correct error. But what if I had no intention whatsoever? And one of the points about freedom of speech is there's so many contexts in which it can arise. What about satires? Well, they don't really have any intention to correct error. What about someone who's just showing off, sounding off? He's just having, no doubt, maybe like in the programme here, or just has what I think colloquially is called a rant. He's on a rant. Now, my lords, I submit that Section 3.2 would not exonerate someone who said, well, I was just having a go, or I was just letting off steam. That, I submit, is one obvious problem with it. The other problem is this. One has to go back to the words. If an act, speech, statement, or publication is not seditious by reason only that it intends to show that the government has been misled or mistaken in its measures, or to point out errors or defects in the government as by law established, with a view to their reformation, or to excite persons, and so forth. So it's not seditious by reason only that it intends to show this. But what happens if you genuinely intend to correct error, but you do so in such a way that is going to create feelings of ill will? Now, in my submission on the proper construction of these words, you're still guilty of having a seditious intention. And my lords, not surprisingly, it might be thought, because the purpose of this is, the purpose of the Act as a whole, is to prevent the stirring up of feelings of ill will, disaffection, and so forth. So, in my submission, all Section 3, subsection 2 does is give a rather limited defence of saying, well, all I was trying to do was to correct error. And you're not to be taken to be guilty just because you're simply trying to correct error. And I say, well, that is far too limited an exception in any event. Now, my lords, I make the following general propositions as to why I say this Act is inconsistent with Section 1 of the Constitution. And I have 7 points I'd like to make, which I shall then run through. I just want to give you the points first, and then I'll run through the arguments and the cases which I say support them. First, under Section 1 of the Constitution, Trinidad and Tobago is a sovereign, independent state, democratic state, sovereign democratic state, and further, under the Constitution as a whole, it is a representative parliamentary democracy, as set out in the main body of the Constitution. My second proposition is this. Section 1 is a substantive proposition. That is apparent from the wording itself of the Constitution, and is also apparent from cases from other parts of the Commonwealth, and also indeed from cases in Trinidad itself. It makes no difference, as a part of my proposition, that Section 1 itself is not an entrenched provision, but can be altered by ordinary legislation. And I say, reverting to the Court of Appeal, the Court of Appeal was wrong to hold otherwise, because the essence of the Court of Appeal's judgment was that Section 1 did not give any independent rights or protection over and above the rights and freedoms set out in Section 3 and 4. I say that was an error. My third proposition is this. in order for representative democracy to function as such, freedom of speech in political matters is essential, and in particular, freedom to say things that are critical of the government or those in office or those in positions of power and influence, subject only to the limitation that the speech is not intended to encourage violence against the government or others, or to incite people to disobey the authority of the courts. This, I say, applies at any stage of the electoral cycle. Fourth, this freedom, and this is an important point in my submission, this freedom is not merely a matter of the individual right to speak freely, but a freedom without which there can be no parliamentary democracy at all, or effective parliamentary democracy as required by Section 1. Fifth, therefore, the requirement of democracy imposed by Section 1 of the Constitution overlaps with, but goes wider than the guaranteed right to free speech and freedom of assembly and association in Sections 4 and 5 of the Constitution. Anything which interferes with this right to speak freely on political matters or public importance is inconsistent with the requirement that Trinidad and Tobago, quote, shall be a sovereign democratic state. Those are the words of Section 1. Therefore, I say, for this reason alone, it is no answer to say that Section 6 of the Constitution insulates pre-existing laws relating to freedom of speech from attack. And further, it is, in any event, no answer to say that because there is a crossover between the notion of democracy in Section 1 and the protection of freedom of speech in Sections 3 and 4, there's no answer to say that therefore Section 1 is necessarily trumped by Section 6. And my lords, for my first proposition, Section 1 of the Constitution, can I go to page 3372? I just want to, perhaps I should start actually at 3371, because 3371 you see what is, properly speaking, the preamble. And you can see, whereas the people of Trinidad and Tobago, I think A, have affirmed fundamental rights and freedoms and so forth, B, principles of social justice, but importantly C, the people have asserted their belief in a democratic society in which all persons may, to the extent of their capacity, play some part in the institutions of the national life, and thus develop and maintain respect, due respect for lawfully constituted authority. Now, my lords, it's not my submission that this preamble itself is, so to speak, a section of the Constitution, but it does inform the rest of the Constitution, and I particularly rely on the notion that all persons may, to the extent of their capacity, play some part in the institutions of national life, and thus develop and maintain respect for lawfully constituted authority. You then get to Section 1.
How does that read across into freedom of speech? How does it, in practical terms, read across into a definitive rule about freedom of speech?
My lords, I don't say in practical terms we say definitive. I wouldn't necessarily say definitive, but in my submission it certainly informs the notion that a democratic state requires everyone to participate in the, as best they can in the functioning of the state, which would be the right to take part in local elections and the right to be informed so as to take an effective part in the processes of the state. My lords, but I do emphasise this is not, I accept this is not what you might call a legislative provision in itself, but it is something which has to be taken into account in construing the width of Section 1 of the Constitution. Section 1, the Republic of Trinidad and Tobago shall be a sovereign democratic state. And then subsection 2 goes on to define the territorial limits. And then Section 2, this Constitution is the supreme law of Trinidad and Tobago, and any other law that is inconsistent with this Constitution is void to the extent of the inconsistency. Now, my lords, I emphasise that Trinidad is now a sovereign democratic state, because in the past, if you go to the previous constitution, there was no such wording at the beginning of the constitution, and there was no president. There was simply a governor-general who was the head of the state, who was appointed by the crown, as I understand it. So there is a difference. Although in large part the 1962 and 1976 constitutions are very similar, there is that important difference. The head of state now is the president, who is elected by the methods set out in the constitution, whereas under the 1962 constitution there was a governor, or governor-general, who was appointed by the crown. And the crown was still the head of state, at least in theory.
Where in the bundle do we have the 1962 Constitution?
My Lord, I think we have that in the supplementary bundle. And if I may, I've lost the reference to it, but it should be 175 of the supplementary bundle. You have the preamble. My Lord, we haven't got all of it, but if you go to 175, you can see the structure of the 1962 Constitution, which will look fairly familiar to your lordships, and in many respects it is very similar to the 1976 Constitution. And if you go to page 181, you will see the preamble in very similar, maybe identical terms, as the preamble to the 1976 Constitution. But then you'll see section 1. It is hereby recognised and declared that in Trinidad and Tobago there have existed and shall continue to exist without discrimination by reason of race, origin, colour, and so forth, various rights and freedoms, which are then set out in section 1, and then section 2 continues. So it is in many respects the same, but with the important difference that the head of state under the previous constitution was the crown, essentially, acting through the governor-general whom it appointed, but now it is the president. Trinidad is entirely independent. And, my lords, I do submit this is not entirely insignificant. My lords, if I can ask you to look at a case, I think it's called the Australia Capital, which is at page 1824. This is a case from Australia, which talks about the difference between, even though it may seem to be notional, the difference between different types of constitution depending on who the head of state is. And one can pick it up, I think I'm right in saying, at 1824. My lords, this was a broadcasting case. It was about licences and broadcasting licences, and it was a freedom of speech case. At paragraph 37 in the judgment, I think, of Chief Justice Mason, but anyway, the judge, yes, Chief Justice Mason, he adverts to the notions of democracy and what the position had been in Australia over the years. And my lords, can I ask you please just to read paragraph 37 to yourselves? Then I just want to make a point on it, if I may. And my lords, The point I seek to get out of it is the first few lines of the paragraph, that the point that Sir Owen Dixon made, which was that there was, in one sense, an obstacle to the acceptance of the view that the Constitution owes its legal force, was an entirely sovereign power, because, of course, it owed its legal force, the previous Constitution owed its legal force as a statute to the Imperial Parliament. But that had been changed, as I understand it, in 1986, about 7 lines from the end, and most recently the Australia Act 1986 marked the end of the legal sovereignty of the Imperial Parliament and recognised that the ultimate sovereignty resided in the Australian people. And that, my lords, is the point I seek to get across in this case, although, of course, the 62 and 76 constitutions were similar. Nonetheless, there is actually a difference, an important constitutional difference. Power definitively now resides in the people under the 1976 constitution, whereas that was not, at least in legal theory, the case in the 1962 constitution, when power still resided in the Crown. My lords, I just should say this. On 1824, the last sentence of paragraph 37, it should be a header rather than a sentence. And it should be the header to what you see in paragraph 38. And can I just, while I'm on this is yet another authority about the importance of freedom of communication in a democracy. Indispensable to that accountability and that responsibility is freedom of communication, at least in relation to public affairs and political discussion. Only by exercising that freedom can the citizen communicate his or her views on that wide range of matters that may call for or are relevant to political action or decision. Only by exercising that freedom can the citizen criticise government decisions and actions and seek to bring about change, call for action where none has been taken, and in this way influence elected representatives. My Lord, I do want to make this point about change, because that is the one thing that colonial legislators did not want. The whole point, in one sense, of this type of sedition law is to prevent change or being encouraged, except by certain, what you might call very polite means, was to prevent that. But the essence of a democracy, or whether people are sovereign, is there is a constant change, and there's no presumption in favour, so to speak, of the current monarch retaining sway.
Mr. Knox, can I ask you, did the Constitution of Australia at this time have any express right to freedom of speech?
I don't think it did, my lord. My understanding from, I don't want to say definitively, but my understanding, my recollection from reading through the authorities, is that it did not have an express right to freedom of speech.
That's my understanding as well. And as I understand it, the significance of this decision by the High Court of Australia is that they were prepared to imply the right to freedom of speech, at least political speech, into the Constitution of Australia, for the reasons that you've told us about.
And it is because it is a democracy.
But does it matter that every constitution has to be read on its own terms and read as a whole, and that what's said in Australia may not necessarily apply to another constitution?
I fully accept that. It can't necessarily apply, but I do rely on it for the general proposition that parliamentary democracy, and there is certainly a parliamentary democracy in Trinidad and Tobago, requires there to be freedom of speech. And it just doesn't work otherwise.
Could I just ask about the 1962 Constitution? So I've gone back to the Appellant Supplementary Bundle, page 181, and the preamble. I mean, I wonder whether you're suggesting too strong a divergence between the 1962 Constitution and the 1976 one, because if one looks at the preamble to the 1962 Constitution, it's all put in terms of the people of Trinidad and Tobago doing certain things, including at sea, have asserted their belief in a democratic society in which all persons may, to the extent of their capacity, play some part in the institutions of national life, and so on. And then at the end, now therefore the following provision shall have effect as the Constitution of Trinidad and Tobago, and of course that includes creation of representative institutions. Yes. So might it not be said that the 1962 Constitution is democratic, just as the 1976 one was democratic? My Lord,
yes, certainly. I certainly accept that. My Lord, I was only making what you might say is the theoretical point, that there is, the 62 Constitution the Crown was still the head, as it were, and was still the head of state, and the Governor-General was appointed by the Crown.
Right, but I mean, even from 1962, the Governor General is not doing the main ruling. The main ruling is through the House of Representatives and by the Prime Minister and the political parties that retain democratic powers, isn't it?
My Lord, I fully accept that, and of course the 1962 Constitution provided for a democratic state. And my Lord, I would no doubt be running the same argument, and I'm now running in relation to Section 1 of the 76 Constitution, even in the 1962 Constitution. But, my Lords, I do submit that now the words are definitively there, they have to be given effect to. And I no longer, whereas it may have been a matter of implication in the 1962 Constitution that Trinidad was to be a democratic state, it is now expressly said to be that, and for reasons I shall come to in a moment, I say it is important that they chose to put those words in their 1976 Constitution. My Lords, that is my first proposition. Trinidad and Tobago is now a sovereign, independent state for the reasons I've given, and that is important. My Lords, my second point is this, that Section 1 is a substantive provision. And if one goes back to Section 1, which is at page 3372, just a point of construction, Section 1, subsection 1, the Republic of Trinidad and Tobago shall be a sovereign democratic state. And then, 2, this Constitution is the supreme law of Trinidad. Now, in my submission, on any normal reading of the words, this Constitution refers back to and includes Section 1. And therefore, it is part of the supreme law of Trinidad and Tobago that the Republic shall be a sovereign democratic state. It is not what you might call a mere appendage. Further, I say this, the important words in Section 1 are shall be. That's an injunction. Shall be, and therefore, in my submission, it must, whatever decision is made by a court, it cannot be a decision that in some way infringes or materially infringes that provision. Now, I say it is evident that this was passed in 1976. This was passed in sort of copycat fashion, if I may say, from the Mauritian Constitution, which was passed in 1973. And that is important because in 1973, there was a decision on the equivalent provision in the Mauritian Constitution, which was later approved by the Privy Council in the case of Koirati, which we've seen reference in our cases. And that decision is at page 3300, a decision of the Mauritian, I think, Supreme Court in a case called Valette at 3300. Mr. Strang reminds me that the Mauritian Constitution was 1968. The decision I'm taking you to was in 1973. My Lords, what had happened in this case was that there had been I think the governor had been given power to alter dates and alter the timing at which an election was to be called. And a complaint was made by an interested party saying, well, you can't do that. And one of the complaints that was made was, what you've done is you've infringed my democratic rights. You've infringed my right to democracy because you've changed around with the dates for, as to when elections are called. One of his grounds of attack was on Section 1 of the Constitution. And he said, this is a sovereign democratic state, therefore you've infringed my constitutional rights. Now, it's fair to say he lost on the facts, but what is interesting is the court's ruling on Section 1. And one can pick it up at page 3306. And the third paragraph. We turn now to the second point made by the applicant and shall consider whether the Act, as he submitted, violates the letter and spirit of the Constitution. The applicant's argument fastened first and foremost on the opening section of our Constitution, Mauritius shall be a sovereign democratic state. One of the fundamental characteristics of democracy, he said, was the possibility for the people to choose their representatives in government by suitably organised free elections. So, by suppressing the limit of time within which an election was to be held, the Act would in effect have the consequences to vest in the Prime Minister or the Governor-General the discretion to postpone, as long as he pleased, any election, incidental or general, and to allow the government of the day to remain in power against the will of the people. That was the argument. One then goes to page 3307, second paragraph. It is at this juncture that the question of justiciability has to be answered. Is this court competent to test the validity of an Act of Parliament by reference to the concept of democracy expressly embodied in the Constitution? And my lords, can I ask you just to read to the end of that paragraph, because it's a long paragraph, but I do rely on it.
So is this right, that there was a general provision in the Mauritian constitution that even if something was prima facie a breach of one of the provisions of it, it could be, the Act could be upheld if it's reasonably justifiable in a democratic society?
Yes, I think that's in Chapter 2. That was in the Fundamental Rights section. That's Section 13. So it would be the same. In other words, the Mauritian Constitution had a similar provision to what you see in Section 13 of the Trinidadian Constitution, namely a supermajority could pass an act which infringed rights, but only if it was reasonably justifiable in a democratic society. And the court would have the power to strike down in relation to that legislation.
Right, but it isn't... I may have read too quickly. Isn't it that which the court is saying is a justiciable matter?
Well, my lord, no, because they're talking about Section 1. I'll come to that in a moment. They're relying on that, the fact that there is a reference to laws being passed with a supermajority, as long as they're reasonably justifiable in a democratic society. There's a reference to that in support of the argument that Section 1 gives rise to a self-standing right. One has to go back to the beginning of that paragraph. It is at this juncture that the question of justiciability. Yeah, but my lord, the question is answered in the next paragraph. But my lords, I don't know if you. It's quite a detailed paragraph. But the point I get out of it is this: the court says initially, well, you might think that you can't give force to Section 1 as a self-standing provision. Reason, I'm halfway down, reason and prudence would prompt a negative answer to this question. But then they go on to say that would be mistaken. The basic principle of separation of powers inherent in our Constitution would seem to require that any broad issue of political organisation founded on the still broader concept of a democratic form of government should be held to be non-justiciable, and yet this view would be mistaken. Rightly or wrongly, the framers of our Constitution have placed on the shoulders of the judges of this court the invidious task of determining, in particular instances, the norms of a democratic society. And they then go on, my lord, to refer to the other reference to democratic provisions in what is Section 13 of the Trinidadian Constitution. My lord, that point is made good, if I may. I should have taken this as well in the following paragraph. beginning apart from these particular instances. My Lords, perhaps I can ask you to read the following paragraph in particular, just going over the page to the conclusion of the that further paragraph. And my Lord, I think it's right to say, it's quite plain from this further paragraph, they are saying in terms that the first section of the Constitution is of itself a self-standing part of the Constitution. You get that in particular over the page 308. The result, it would seem, is that Section 1 of the Constitution must be viewed not merely as an interpretive adjuvant in ascertaining, for instance, the policy of a statute, but as an express provision of the Constitution to which ordinary legislation must yield. Now, my Lords, I submit that's absolute. And what is significant about it is this is said in 1973, before the Trinidad Constitution comes into effect, the Trinidad and Tobago Constitution comes into effect. And what is also significant is this passage has been expressly approved by the Privy Council itself in the later decision of Koirati.
And what about the following paragraph where the court seems to set out restrictions on the approach?
Yes, well, my Lord, one further consequence. My Lord, I would accept that obviously the court has to, as it were, give a margin, I imagine one might say a margin of appreciation to the democratic legislature. But my Lords, I would accept that. And my Lords, if your Lordships could read that paragraph yourselves.
And how does one deal with the what on this approach would be the overlap between Section 1 and the specific rights in what we have in Sections 4 and 5?
Yes.
How do you address that?
Well, my Lord, in my submission, the fact there's an overlap doesn't matter. If there is an overlap, the question is not, is there an overlap? The question is simply, is this legislation inconsistent with the provision that Trinidad shall be a democratic state? If it is, then that is that. It is no answer to say that there's an overlap with Sections 3 and 4. Sections 3 and 4, of course, sorry, Sections 4 and 5, freedom of, because what we're here talking about in particular is political freedom of speech. Now, Sections 4 and 5 are just generally freedom of speech and freedom of association and so forth. They would govern, for instance, straightforward things like newspaper publications about individuals, people publishing stories about lots of political interest.
They cover political freedom of speech as well, wouldn't they?
They do, they certainly do. I say that doesn't matter. My Lord, if there had been a complete coincidence between the freedom of speech provisions in Sections 4 and 5 and the notion of a sovereign democratic state, then, my Lord, the point might have some force. But my submission is that doesn't matter. There are certain types of speech which are essentially in the nature of political speech, of the sorts which I have mentioned, which in my submission are protected by Section 1 regardless of Sections 4 and 5. And, my Lords, if one is looking at Section 6 of the Constitution, which I shall have to do at the moment, it is quite plain from Section 6 that all it is doing is insulating from attack old legislation on the footing that it infringes Sections 4 and 5. Section 6 does not, however, preserve from attack legislation which is inconsistent with Section 1. And, my Lord, that is a point which runs through the authorities there's Koirati and the case of Mollison and so forth. If I can give an example, the case which started all this off was a decision from Jamaica called Mollison, in which I think a young man was found guilty of an offence, and the punishment was that he be detained at His Majesty's pleasure, or the Governor's pleasure. Now that was held, now the argument ran, well that's inconsistent with my fundamental rights and freedoms under the Jamaican Constitution, to which the argument was, oh well, it's an existing law, so you can't get around it that way. And Mr. Fitzgerald, who represented the appellant, then said, oh well no, I've got another way around this one. It is inconsistent. The notion that the Governor General should be in charge of deciding the sentence is inconsistent with the separation of powers principle implicit in the Constitution. And that was upheld. And Lord Bingham does say in his judgment, words to the effect, I'd never thought of that myself, type of thing. That's a surprising submission, but he then goes on to uphold it. He says it's right. Now, my lord, that is a good example of how the fact that you're barred by Section 6 from bringing what you might call the most obvious complaint doesn't bar you from bringing a different complaint as long as you can legitimately do it. And that is because the savings provision saves only laws from attack for inconsistency with Sections 4 and 5. It does not save from attack laws which are inconsistent with Section 1. That is the fundamental premise.
And Lord Bingham's judgment is at what page?
It's in Mollison, my lords. It's in the supplemental bundle. I'm conscious of the time, my lord, but I will give you the reference, if I may. Sorry? 45 of the supplemental bundle. Starts at 45 of the supplemental bundle. But, my lord, that, in a sense, is the leading case. And there have been a number of other cases on this very point in relation to Trinidad and Tobago, which I would, if I may, just briefly come to. My lords, I think, in a sense, I've jumped ahead of my propositions, but my second proposition was that this is a self-standing provision. Can I come back to Mollison and Co. later, if I may? I've taken you to Villette. The importance of Villette is made plain in Koirati, which was the decision of this board from Mauritius. It begins at 3044, and my lord, this case concerned an attempted amendment to the Mauritian constitution to prevent bail ever being granted in certain drug trafficking and terrorist cases.
Could you give us the page again, please?
3044.
3044.
3044. That was the nature of the case. My lord, I apologise, this should be in the appeal case reference, but anyway, we've got the Privy Council printout here. And my lord, the basic problem was this, that the Mauritian government had passed a constitutional amendment with a two-thirds majority, I think it's a two-thirds majority, which provided that no bail should be granted in certain types of cases, drug trafficking. And on the face of it, that was a perfectly proper way of passing the amendment. However, there was a problem, because Section 1 of the Constitution, which is what I've been talking about, provides for sovereign democratic state, and Section 1 in Mauritius could not be altered, save by, it was deeply entrenched, save by, I think, unanimous vote in the House, plus a referendum. And so the argument went that although on the face of it, the Act had been brought in the right way by a two-thirds majority, nonetheless it was inconsistent. The deprivation of bail in all cases of drug trafficking and terrorism was inconsistent with the separation of powers, and in particular with the notion of a democratic state. And on that basis, the Privy Council upheld the lower courts below and said, yes, it is inconsistent. The deprivation of bail in all cases of terrorism and drug trafficking, without any right to ask for it, is inconsistent with the notion of sovereign democratic state. And in the course of the judgment, Lord Stane, Lord Raja and Lord Mance also gave judgments, but specifically approved the Villette case, which I've taken you to. And my lords, one can pick it up at paragraph 11. The context. And my lord, Lord Stane refers back to a previous decision of his in Arney and the DPP, where he explains the structure of the Mauritian constitution. I just draw it to attention because it is in very much the same type of form as the Trinidadian constitution. It's the Westminster model constitution with similar provisions. And then at page 3052, near the foot of 3052, the final paragraph, from these provisions, the following propositions can be deduced. First, Mauritius is a democratic state constitutionally based on the rule of law. Second, subject to its specific provisions, the Constitution entrenches the principle of the separation of powers between the legislature, executive and the judiciary, he's echoing Mollison. Under the Constitution, one branch of government may not trespass upon the province of any other. Thirdly, the Constitution gave to each arm of government such powers as were deemed to be necessary in order to discharge the functions of a legislature, executive and judiciary. And then he continues, it's worth emphasising that Mauritius is a democratic state based on the rule of law, the principle of separation of powers, entrenched, and so forth. And then paragraph 12, the board proposes to analyse the question in a number of steps. The idea of democracy involves a number of different concepts. The first is that the people must decide who should govern them. Secondly, there is the principle that fundamental rights should be protected by an independent and impartial judiciary. Thirdly, to achieve a reconciliation between the inevitable tensions between these ideas, a separation of powers between legislature, executive and the judiciary is necessary. And then 13, in the DPP v Mollison, Lord Bingham examined the separation of powers and said, whatever overlap there may be under the constitutions on the Westminster model between the exercise of executive and legislative powers, the separation between the exercise of judicial powers on one hand and legislative and executive on the other is total, or effectively so. Such separation is based on the rule of law, and so forth. So it was, in this case, it was held that to prevent bail from being granted in terrorism cases, drug trafficking cases, in all cases, without any discretion at all, was held to be inconsistent with the notion that Mauritius was a sovereign democratic state. Now, my argument is simply this. Freedom of speech is a fortiori. It is, one would have thought, if you're prepared to, what you might call, stretch the notion of a sovereign democratic state to bring into account what you might think are matters of relating to the courts themselves, I'd certainly submit in relation to freedom of speech, which is so obviously part of a democratic state, the same principle must apply. And in particular, freedom of political speech. My Lord, I think, my Lords, I should have taken you to paragraph 15
of Koirati.
Of Koirati, 3055. Section 1 is not a mere preamble. It's not simply a guide to interpretation. In this respect, it's to be distinguished from many other constitutional provisions. It's of the first importance that Mauritius shall be a democratic state, is an operative and binding provision. Its very subject matter and placed at the very beginning of the Constitution underlies its importance. Now, my Lords, a lot was made about the point that there was entrenchment, deep entrenchment of Section 1, but in my submission that was only because, or principally because, the whole argument turned on Section 1 being deeply entrenched. If Section 1 had not been deeply entrenched, then of course it might be said that an act passed with the two-thirds majority could easily be taken to oust, if you like, a provision which could be removed simply by simple legislation. And that's why there was obviously emphasis on this point in the Koirati case. My Lords, finally, on this, can I just draw your attention to 19, paragraph 19 at 3057. You'll see why, if I can just ask you to look at that, you'll see why I have referred to Valette. It's got the seal of approval from the Privy Council. And of course, Valette was a much more closely associated a case much more closely associated with the freedom of speech points, being about elections and so forth. Now, my Lords, the reasoning in Koirati has been applied, I can deal with this, I hope, briefly, has been applied in Trinidad and Tobago. My lords, if I can just tell you what the cases say, because I'm conscious of time. At page 2295, there's a case of Sukran. And the problem in that case was there were some old prison rules passed in 1948 or thereabouts, which said that anything a prisoner said to his attorney, or indeed to anyone, had to be in the hearing of a prison officer. Now, that obviously gives rise to a bit of a problem. What if he wants to give legal instructions? That would infringe his right to privilege. And the point was taken by the prisoner, my fundamental right to communicate with my lawyers being infringed, to which, needless to say, the state answered, bad luck, Section 6, this is an old law, it's an existing law, Section 6 prohibits any interference with it. And Madam Justice Goben, at first instance, in a fairly detailed judgment, begins from paragraph 27 at 2307 and finishes at 2311, paragraph 34. She discusses this point and says, well, the ability to liaise freely with your lawyers and the importance of privilege is such that even though Section 6 bars an attack or prevents an attack on the basis of inconsistency with Sections 4 and 5, nonetheless, the provision is inconsistent with Section 1 of the Constitution. In other words, and therefore the prisoner was able to win by reference to Section 1, regardless of the bar in Section 6. And my lords, again, in Achille Charles, the Court of Appeal decided, in a case that came up here, but it didn't have to be, at this point didn't have to be resolved, the Court of Appeal decided, the Chief Justice said in terms, that it is beyond argument, I think those were his words, that Section 1 is a provision which has force and should be given force to. And the references are, if I may, it's at page 1697, paragraphs 67 to 69.
Which paragraphs, sir?
Paragraph 67 to 69. Yep. And further, there's a decision of Lord Roger in Belwant in about 2009 or thereabouts, which was another case about police regulations, old police regulations, but he observed in passing that even though a law cannot be, even though Section 6 applies to strike down for inconsistency with the fundamental rights and freedoms, it doesn't apply so as to prevent attacks on other bases.
Please.
Paragraph 13 at page 77 of the supplementary bundle.
And what was the name of that one?
Belwant.
Sorry, the paragraph.
Johnson and Belwant. Page 77 of the supplementary bundle. So my submission, this line, and my lords, one understands why Lord Sales raises the point, but this line that somehow surely it's all swept up, the Section 6, so to speak, trumps everything, has been expressly disapproved in relation to Trinidad. My lord, I come to my third point, which is one I've made before, but so I can deal with it briefly, I hope. In order for a representative democracy to function as such, freedom of speech in political matters is essential, and in particular freedom to say things that are critical of those in office, subject only to the limitations which I've mentioned. And my lords, can I just, for your note, mention two particular cases which are mentioned in our case. There are references from Boucher, which I didn't take you to, but they are mentioned at paragraphs 50 and 51 of our case. And the second is the Australian Australian TV case, television case, which I've shown you, at 1826, paragraph 42. My lord, I now come on to a fourth and important point. This freedom is not merely a matter of individual right to speak freely, but a freedom, a structural freedom, without which there can be no parliamentary democracy. I would like to take you, if I may, to the case of Lang, I think I'm right in saying an Australian decision, which one sees at page 2426. Begins at 2412. And this was a case which arose out of a programme which defamed, or not, the former Prime Minister of New Zealand. And he begins proceedings, Mr. Lang, that is, he begins proceedings in Australia, complaining about the defamation, and all sorts of problems arose about qualified privilege and whether it would apply to him as a New Zealand politician and so forth. But the relevant passage I want to draw attention to is at 2426. And it's halfway down the page. That being so, can I just ask you to read the paragraphs, that being so, section 7 and 24, to the end of the page. And my lords, the passage I particularly rely on is the paragraph in Cunliffe and Commonwealth. Brennan J. pointed out that the freedom confers no rights on individuals, and to the extent that the freedom rests upon implication, the implication defines the nature and extent of the freedom. The implication is negative in nature. It invalidates laws and consequently creates an area of immunity from legal control, particularly from legislative control. My lords, I particularly rely on that because here that's why I say this is not court. Certainly freedom of speech in political matters is not court, is not the same thing generally as what you see the particular right to freedom of expression is. Freedom of thought goes further. It's a wider notion. And it's not based on the notion of rights, it's based on the notion of democracy itself.
And the limitation again, if you just express that to me again?
Well, my lord, actually, I can probably do no better than what the court went on to say. Right. But the limitation would be, if you go to page 2427, they do make the point that if the law is enacted for a legitimate end, then of course there may be different. Then it may be justifiable. You can't just say this is an anti-democratic law, when let us say there are very good democratic reasons for passing it. It begins at 2427, second paragraph, my lords. That sets out what the High Court said was the, if you like, limitation, but, my lords, I don't dissent from that.
This is the paragraph beginning, however the freedom can...
Yes.
Yes, thank you.
Not absolute.
How does that all translate in the internet age and an age of fake news?
Well, my lords, I don't think I'm in a position to answer that. It would, on the, in my submission, we're not here dealing with what you might call the problems of people.
You're saying that there is a simple principle, that is that democracy depends upon freedom of communication. And I was asking you basically what the limitations on that were and how that applies in modern societies where you have a problem about fake information,
yes,
where you have potentially other states interfering in elections and so on. So,
well, my lord, I think, I hope you don't mind my saying, my short answer might be a bit of a cop-out. Well, that would be a matter for individual legislation to deal with that particular problem, but it wouldn't be caught by sedition laws such as this.
Well, it's a bit late after you've had your election if it's all been based on fake information.
My lords, it may be, but one answer might be it's all a bit late anyway, once the election's taken place. But, my lords, no doubt one needs to have laws to restrain what you might call the provision of mass fake information, which can affect the elections. But, my lords, a sedition law is not the thing, is not the way of doing it. My lord, my fifth point was that the requirement of democracy imposed by Section 1 of the Constitution goes wide in the right to free, goes right in the relative rights to freedom of speech and so forth in Sections 4 and 5. My lords, can I just mention in this context the case of Gaddafi, which was in the a decision of the Indian Supreme Court, I think in about 1972, where they held that the sedition law, which they had, would have been unconstitutional, except they were able to interpret it by reading in the requirement for incitement to violence and so forth. My lords, for the law, for the relevant sedition law, which I think was based originally on Lord Macaulay's draft, or Macaulay's draft, 2406, you can see the law itself, and then you can see it's Kedar Nath Singh. 2406 is the law itself, and at pages 2409, halfway down to 2410, there is a discussion about whether or not the law was inconsistent with the protection of freedom of speech, and they concluded that it was, but it could be saved by reading in provisions for intention to cause violence or public disorder.
Sorry, what was the second page reference you gave
2409, halfway down to 2410. And, my lord, it was the Law Commission report, which perhaps I should take you to, is at 396 of the supplementary bundle, paragraph 10.1, because it just gives you the flavour of the matter. This is in our supplementary bundle. This was the report made last month, and it recommended that that decision should be upheld. It recommended that to the Supreme Court. And so page 396 of our supplementary bundle. You'll see, if I can just ask you to read that yourselves. They actually recommend that the Kedar Nath decision be upheld. In other words, read in incitement to violence and so forth.
Why could something similar not happen if the circumstances of a particular case required it under the Constitution of Trinidad and Tobago? Well,
my lord, the difficulty with that would be, in the case of Kedar Nath, it was quite simple. It wasn't a particularly complicated sedition law. The difficulty here is that there's a fairly detailed scheme, and we refer to this in our case, but it's the case of De Freitas, which is in our case, and my lords, I can't remember which page number it is, but that was a case in which it was essentially said that in the case of rights to freedom of speech and so forth, it is very dangerous for the court to assume the role of a legislator. My Lord, Mr. Strand has just given me the reference, but there's quite a long reference from Lord Clyde where he incorporates, I think, a decision of Mr. Justice Brennan, and we refer to it at the end of our written case. So we say this would not be a case where one could simply read in some sort of extra intention or extra requirement. That would be the wrong way of going. You wouldn't be, so to speak, saving the law in accordance with its original intention. You would actually be altering the law itself. And my lord, there is also a case called Wallace-Johnson, Privy Council decision, which again we refer to in our case, where they considered a very similar type of sedition law, and the argument ran on behalf of the appellant, you should read in some sort of limitation, like with intention to cause violence. And the Privy Council said, no, we're not going to do that. The words are absolutely plain.
And that's called Johnson?
Wallace-Johnson. My lord, 331, 3314. Sorry, 3314. Yes, that's Wallace Johnson. And the De Freitas case, well, forgive me, I don't have the reference to hand, but we refer to it in our written case in extenso. It may be the simplest place to find it. We refer to it at the end of our written case. My Lord, at 1648, paragraph 131 of our written case, and in the bundles it's at 2089 sub 1 to 20892. Something went wrong with the page number. So in my submission, it's not permissible to read down in order to save an act which is fundamentally flawed. My Lord, that is, my Lord, one accepts the point does arise, but this is just too detailed to save. And you have the Privy Council decision saying that's not the right way of going around it. My Lords, I acknowledge that there are some differences between sections 3, between the various subsections. But again, I make the same point. If you leave out E in genocide, I submit they are all fundamentally flawed because they just go too wide and make too many things a criminal offence, and they create a sense of fear in relation to political speech.
Mr. Knox, you've got 10 minutes left.
My Lord, I'm only going to take one more minute. My Lord, our alternatives, I know Mr. Maharaj wants to say something. My Lord, yes. Our alternatives...
That's why I draw to your attention.
Yeah, thank you. I might can have 1 minute, because we did adjourn for 1 minute, but take every point going, my Lord. In relation to existing law, yes. You see what we say in our written case. We take the following points. Section 6 is a derogation of fundamental rights provisions. That's clear. Secondly, it is clear from the authorities that you have to give a narrow construction to savings clauses. Thirdly, the question arises, should you give, what construction should you give to a savings clause when the law that is under challenge is so vague, as we say it is, and leaves so much to the discretion of the prosecutor that at least in one sense it can be said not really to be a law, or properly speaking, a law at all. And that's the point we make. And we say, properly speaking, it is so vague and leaves so much to the discretion of the prosecutors, it is not a law at all. And indeed it might be said, by virtue of that, to infringe the separation of powers principle. Now, the contrary argument would be, well, law just means law, any old law, it doesn't matter. But we say, bearing in mind the general provisions, general doctrine, that you must give a narrow construction to savings clauses, where you have a law which is as offensive as we say this law is, it cannot survive attack by virtue of Section 6. And, my Lords, we settle this out in our case in some detail. My Lords, those are my submissions.
Yes, thank you very much. Mr. Maharaj.
Much obliged, my Lord. My Lord, the first point I would like to make is to show in practice how sections 3(1)A, B, and C of the Sedition Act affect the citizens of Trinidad and Tobago in the context of Trinidad and Tobago being a sovereign democratic state. Its citizen is at risk of criminal sanction merely for saying something which has the tendency, for example, to excite disaffection against the government or its constituted authority, or raise discontent among his fellow citizens. Even though his criticisms or statements are not accompanied by an intention to cause violence or disorder, what he says attracts criminal sanctions against him. That citizen can be prosecuted for a sedition offense, and if convicted, he can face imprisonment for 2 years on summary conviction and 5 years on indictment. The 5-year term of imprisonment makes sedition an arrestable offense. A police officer can arrest a citizen without a warrant if there are reasonable grounds to suspect that the citizen has committed or is about to commit an offense of sedition. And I just refer to paragraph 5 of the case for the appellant, that's at electronic bundle 1617. and with a warrant, my lords, the police may search a person's premises pursuant to Section 13 of the Act and seize anything found on the premises. The mere threat of arrest of the citizen and the search of his premises have a chilling effect on the exercise of free political speech by the citizens of Trinidad and Tobago, be they dissidents or reformers, civil rights activists, trade unionists, or politicians of every leaning. These provisions, therefore, in all respectful submission, give a great discretionary power to the prosecuting authorities, which in the wrong hands can damage the very fabric of the sovereign democratic state. The next point I would like to make is that the respondent at paragraph 69 and 72 of its case, EB 1671 and 1672, relied on the fair trial process and the independent office of the DPP, whose permission is required to bring a prosecution as moderating the harsh effects of the law. We submit that is not enough to undo that damage done by the law. The DPP has a discretion over whether to bring a prosecution, but he has no say over the arrest of a citizen or the execution of a search warrant. Neither the DPP's discretion nor the guarantee of a fair trial prevent the chilling effect which the law has for citizens to be arrested and for their premises to be searched. The next point I would like to make, my lords, is that at paragraph 88 of the judgment of the judge at first instance, that's at page electronic bundle 345, the learned judge referred to the context in which the 1920 Sedition Act was passed. His lordship reminds us that the Sedition Act was passed during a turbulent period of labor unrest to protect the interests of those who governed in the colonial era. He reminds us that the Sedition Act was used to prosecute and jail one of Trinidad and Tobago's national heroes, Uriah Butler. And he reminds us of the words of the banned calypsonian King Radio, who sang a calypso about the effect of the sedition laws in the colony, on the then colony. Trinidad and Tobago, my lords, very famous for its calypsos. Those calypsos are usually political and social commentaries on issues in the society. King Radio's calypso, entitled Sedition Law, commented on the effect of sedition laws in the country. The learned judge cited some of the words in the calypso, and I would like just to quote a few words to put it in context of what King Radio said. Believe I warning the rich and poor, be careful, friends, today from this sedition law. If you talk without defense, you have no evidence. They mean to lighten me out, they don't want me to talk. But you gotta know, friends, what you're talking about, and you're sure to pay damn dear for your mouth. They mean to lighten me out, they don't want me to talk. I thought since being because as the board is the Supreme Court of Trinidad and Tobago, the final court of Trinidad and Tobago, it's good to put those words in context, my lords. The judge also at paragraph 154, the electronic bundle 364, cited the words of the King of Calypso of Trinidad, the mighty Sparrow, saying the people of a country should be free to talk their mind. Those words, my lords, came from Sparrow's song entitled Sedition, which he sang in 1972, after the revival of the Sedition Act in 1971 by the then government during the state of emergency. I would like to cite for the board just a few words of the song to put in context what the mighty Sparrow said. Oi, you better put your tail between your legs and play it cool, cause anything you say, we're going to call it ridicule. The laws must change up, yes, but Lord, this one too fierce. The people of a country shouldn't afraid to talk their mind. If you're guilty, you're straight to jail without a fine. The fourth point I would like to refer the board to is the contents of the Law Commission of India in its report, which is in the Appellant Supplemental Bundle of Authorities, and it starts at page 314, but I want to refer to page 377 at paragraph 8.4, in which it states, having referred to the development in the trend taken to abolish the sedition laws, it stated at the middle of paragraph 8.4 at page 377, the global trend has largely been against sedition in favor of free speech. While abolishing sedition as an offense in 2009, the then parliamentary Under-Secretary of State in the Ministry of Justice of the United Kingdom reasoned that sedition and seditious and defamatory libel are arcane offenses from a bygone era when freedom of expression wasn't seen as a right it is today. The existence of these obsolete offenses in the country had been used by other countries as justification for the retention of similar laws which have been actively used to suppress political dissent and restrict press freedom. Abolishing these offenses will allow the UK to take a lead in challenging similar laws in other countries where they are used to suppress free speech. So, my lords, I would respectfully submit that in 1962, the British government gave to the people of Trinidad and Tobago an independent constitution. It made the courts of Trinidad and Tobago with all the powers necessary to declare any act of the state unconstitutional, whether it is the act of the executive arm, the legislative arm, or the judicial arm. This was a new remedy given to the people of Trinidad and Tobago. In the 1976 Constitution, that new remedy continued in Section 14 of the Constitution. But as my learned friend Mr. Knox submitted, in 1976 there was a fundamental change. The president of the country was elected by the parliament, representing the true will of the people. The sovereignty of the people changed from the sovereignty of the monarch to the sovereignty of the people. The people elect the representatives in parliament. If the people are restricted in exercising freedom of speech, political speech, it will have a detrimental effect to the enjoyment of democracy. And in closing, may I respectfully submit that the freedom of speech, political speech, is probably just as important as the right to vote. Much obliged, my lords.
Yes, thank you, Mr. Maharaj. Mr. Hussain.
Thank you very much, my lords. There are two limbs to the appellate's argument. The first limb is that the Sedition Act is vague and uncertain, and therefore is not a law, and thus it does not qualify to be seen as an existing law under Section 6 of the Constitution. The second limb, and alternatively, is that the Sedition Act violates the principle of freedom of expression and freedom of speech, which is a central tenet of a democratic state, and therefore invalid under Section 1. I should mention in passing, my lords, that there are several rights which are engaged here. And if we look at Section 4 of the Constitution, there's a right to join political parties and express political views. If you look at
the page number,
3377 of the 1976 Constitution. I beg your pardon, my lord.
Thank you, Rushdie.
Section 4, again at 3377, I, freedom of thought and expression. And K, freedom of the press. So we take it that those four rights are engaged here. I propose to deal with my arguments in an inverted way. First of all, deal with the Section 1 and deal with the savings rights provision, and then take you briefly into an analysis of the Sedition Act. Because I think if we succeed in establishing that this is an existing law, that necessarily will be the end of the argument. But before I begin, could I encapsulate briefly what I think is the appellant's case? They are saying it's really an archaic law passed in 1920, and historically has been used in the British colonies as a repressive measure, not taking into consideration the fact that there are sedition laws enforced now in Canada, in India, and only abolished in the United Kingdom in 2009 under the common law, as the case may be. The second thing is they say it's vague and uncertain in many parts, and therefore open to abuse by the prosecuting authorities. We say to that before a charge is made under the Sedition Act in Trinidad and Tobago, the Director of Public Prosecutions is the authority that has the power under the Constitution to really vet which charges should be preferred or not. And they say, fourthly, it violates the tenets of a democratic state. Now, let me begin by making a number of very large preliminary points. And the first one is no one has been charged for an offense in this particular case. This is not a challenge to a conviction. It is a freestanding challenge as to the status of an existing law, all of it, not any particular section, which is saved by Section 6 of the Constitution. Because no one has charged, no one has gone to trial, and therefore no facts have been found, and there is no fact pattern upon which to allow the party in this matter to make focused submissions. It is a challenge to the Sedition Act at large. The allegations made by Mr. Maharaj, who is deceased, is there in the papers, and I don't propose to read it, except I say that they are highly volatile statements in a country that is a twin republic, 2 islands, and which is divided, which is a country that's heavily ethnically divided. And therefore one can't say that, first of all, it is not worthy of the execution of a search warrant, which is not challenged in this particular case. There's no challenge to the search warrants, at least not in these proceedings, and a country that is racially divided. And secondly, even modern society recognizes the fact that there must be some kind of constraint in respect of freedom of the speech. For example, there's legislation in respect of race relations, in respect of hate speech, and as we mentioned in Suraj, the freedom of expression or freedom of the press is always subject to a proportionality argument. You can't say that the Sedition Act is unconstitutional because it violates one, because that will entail the court eventually in getting into a proportionality argument, if we get there, as to what portion of it should be retained. And having regard to the fact that the entire act is being challenged, that is going to be a difficult task in this case. This case is very highly theoretical, and no assessment of the facts are there to determine what should be done. Now, I will examine the act in the very end, but there are defenses open in the act, and the defenses are without lawful means in some cases, or statements made with a view towards reforming the law, as the case may be, or acting in a way that will allow the law to be reformed. The other point I wish to make is that my little friend quite properly took the court to a number of jurisdictions, India, Canada, and the United Kingdom. And I say in respect of that, in respect of those sedition laws, that every country has its own sedition laws, and therefore has its own constitutional context in which those sedition laws may be interpreted, has its own savings provisions, has its own fundamental rights, has its own protections, as the case may be. And therefore, in all of those cases, with the exception of the case out of Pakistan and Turkey, the Farouk and the Federation of Pakistan, which is that the tab 4 of the authority, we find it in a minute, and Akam against Turkey. All of those cases deal with situations where persons have been convicted, and therefore there's a fact pattern on which to write the judgment as the case may be. Now I say make one simple suggestion before we take the break in respect of how we deal with it. The little friends say that the Sedition Act in Trinidad is vague, and therefore the defenses are limited. But that is a matter which judges deal with at all times. For example, in the case of Ziegler, which is found in the supplemental bundle of the appellants. And I'll ask my two little friends to find me the citation in a little while. The defense in that case was without lawful excuse, and therefore the court in those circumstances dealing with one section 137(1) of the legislation as against freedom of expression and assembly in Articles 10 and 11 of the convention, had to determine on the assessment of those facts, and the court said it, whether in fact there was an interference that was necessary in a democratic society, and the proportionality argument was engaged. So therefore you need specific facts, and you need to determine whether in the context of those facts, what constitutes without lawful excuse. And I will address that when I get to dealing with the Act itself. Now, might I make a few comments about the structure of our Constitution, which is going to assist us. Now, the 1962 Constitution, beloved friend, does not have a Section 1 provision. It does not. But it did not mean in 1962 Trinidad and Tobago is not a sovereign democratic state, because there, as was said in the Mauritian case, which was cited to your beloved friend, which preceded the Coriati, that democracies take various forms, and it depends on the internal structure within the state, as legislated on by the founding fathers, by the constitution makers, by the referendum, by the parliament as the case, what constitutes a democratic state. And it can't be that we were not a sovereign democratic state before 1962 because we had an independent parliament. We had a head of state who was appointed by Her Majesty, as the case may be, on the advice of the Prime Minister. We had judicial review of legislation. We had an independent parliament, a senate, and we had all the requirements of an independent state. So therefore there was no great change in 1976, except Her Majesty was no longer the head of state, and the head of state was now elected by the parliament, as the case may be. We had even judicial review of legislation, and my lords will see the case of Collymore against the Attorney General in a judgment delivered by Chief Justice Wooden, which is found in our supplemental bundle at page 30 of our supplemental bundle.
Page 34.
30. And there is an extract there. There's an extract that deals with the issue of how he viewed a challenge to legislation as early as 1967 under the 1962 Constitution. And that extract is found at page 34 of the number 2 supplemental bundle, Respondent List of Authorities. And he said at somewhere between paragraphs A and B, I'm accordingly in no doubt that our Supreme Court has been constituted and is the guardian of the Constitution. So it is not only within its competence, it's also its right and duty to make binding declarations if and whenever warranted that an enactment passed by Parliament is ultra vires and therefore void and of no effect because abrogates, abridges, or infringes or authorizes the abrogation, abridgment, and infringement of one of the recognized rights and freedoms.
Mr. Hussain, could you give me the reference again, please?
The reference again is on page 34.
Of the supplement.
Second supplemental bundle. The case is Collymore and Abraham against the Attorney General of Trinidad and Tobago. Do you have it, Malloy?
I've made the note. I've got the reference. Thank you.
The number 2 supplemental bundle. It also contains the case of Day against the Governor of the Cayman Islands.
I think in our list it's called
Respondent for supplemental bundle. That's what it is.
Yep. I beg your pardon.
Thank you.
No. I would like to state a few simple matters which I know the board is well aware of. Trinidad and Tobago is a constitutional democracy. It is not a parliamentary democracy. Every country is entitled to invest its courts with different powers. In the United Kingdom, the courts are invested with the powers to deal with a law and make a declaration of incompatibility. In Trinidad and Tobago, the courts are invested with the powers under Section 2 to declare a law to be inconsistent with the Constitution to the extent of the inconsistency. And that, again, is a facet of the peculiar constitutional arrangements in a democratic society. The fact that Britain has chosen another path does not mean that it is not a democracy. In Belize, for example, there's a savings law provision. If I may just say it off my head, it's a savings law provision that gives the court the power to modify legislation for a period of 5 years. In Grenada, the modification continues, and that was the case of Worm, which I'll refer to and give you the citation in a short while. So it depends on the framework. The other point is judicial review is not a common law remedy. So therefore, it is not open to any court to declare any law, in this case the Sedition Act, inconsistent with any kind of template or inconsistent with general principles of vagueness, general principles of being too wide, too much breadth as the case may be. What did courts do in those cases? And I'll address that. They apply the principle of legality and they read down into the legislation what is required to make sense of it. So judicial review only arises, and they have asked to avoid the legislation here, only arises in respect of those permissible areas that Parliament has allowed the courts to enter into.
Mr. Hussain, sorry for interrupting, but do you accept that Section 1 is an operative and binding provision?
Absolutely, my Lord.
And so, do you accept, therefore, that if a law contravenes Section 1, that it can be struck down as being void?
No, my Lord. I'll deal with Coriati from that point of view.
Yeah.
Section 1 has traditionally and always been interpreted by this board as containing large macro-constitutional principles, separation of powers and rule of law. And that is the template on which it is built. The fundamental rights are in 415. So the concept of a sovereign democratic state does not confer granular rights on a citizen. What it does, it allows the court to deal with legislation which violates large concepts, large unwritten concepts that constitute a democratic state. And that takes me straight into Coriati, if I may deal with that. Coriati is a case where Section 1 was in... Section... Is it time, my Lord?
No, you carry on.
I just finished Coriati. Coriati is a case, my Lord, which deals where Section 1 was deeply entrenched. There was a... In order to change Section 1 sovereign democratic state, you had to have a 3/4 majority on a referendum. You had to have a unanimous vote in the assembly in order to change Section 1. It was deeply entrenched. What happened in Coriati, an attempt was made to amend the Constitution, to amend the laws in respect of bail, for persons who were involved in drug trafficking. And the issue arose as to whether the attempt to amend the Constitution met the threshold prescribed by the law. And the Privy Council said quite correctly in our view, in Coriati, that first of all, it touches on a judicial discretion, a traditional area of judicial activity, namely separation of powers. That's the first point, and we accept that absolutely. Secondly, the question of separation of powers is encompassed and captured by Section 1 of the Mauritian Constitution, sovereign democratic state. Separation of powers being a subset of the rule of law. Number 3, separation of powers is not a supra-constitutional principle, as Lord Hoffman said in Rez and in Matthews and all of those cases, it could be attenuated as the case may be, and in all of these constitutions, they are attenuated in some form or fashion. But the problem in Mauritius is that the Parliament could not override Section 1, the entrenched requirements in Section 1, and therefore the separation of powers doctrine was engaged to strike down the law, not only in terms of the doctrine as a freestanding doctrine by itself, but rather as an intrinsic part of Section 1 of the Mauritian Constitution. And that is the way Coriati has to be looked at it. It's really an entrenchment case. It's really a breach of a provision in a constitution which is deeply entrenched. And the inability of the Parliament to get beyond that. Whether it can do so in its own right is on the basis of violating separation of powers is another issue by itself, which we need not approach here, but that is the effect of Coriati. And it's no more or no less than that. Coriati does not go beyond the principle of separation of powers. It stops there. The same argument was raised in Chandler, the same argument was raised in Matthews, the same argument was raised in Mollison. And we accept absolutely the judgment of the board in Mollison, because Mollison dealt with the question of whether the Governor General, who could allow you to be released at his pleasure, whether he's exercising a sentencing authority, and the board properly said no, that's a separation of powers issue. So Mollison respectfully is of no help to my learned friends and to the appellants in this particular case. And then the final point is one I touched on before, and that is the issue of Section 1 cannot be untethered, according to Lodgehart in Chandler, cannot be untethered from the rest of the Constitution. The Constitution has to be read as a whole, and Sections 1 and 2 are the preliminary sections of the Constitution. Sections 4 to 14 comprises the first chapter, and when you look at it, the first rule in reading any statute is that, first of all, you have to read it as a whole. Constitutional interpretation is a little bit different from the interpretation of a commercial document. You don't look at a constitutional document respectfully and look at it and say, look, all the rules of interpretation apply to it. When you look at 4 and 5, it has to be given a generous interpretation, devoid of the austerity of tabulated legalism, according to Fisher. When you look at Section 6, Matthews establishes that, Chandler establishes that. It has to be given a very narrow interpretation. When you look at Section 1, Section 1 has to be interpreted in light of 4 and 5, and it can't be untethered. And what you do is you ascribe to Section 1 the meaning that so far the board has given to it. Because what you have is, if you don't look at Section 1, if you look at Section 1 more extensively than rule of law and separation of powers, you stand the chance of where does Section 1 end and where does Sections 4 and 5 begin, as the case may be. There can't be a duplication of the fundamental rights in Section 1, which are contained in 4 and 5, because 4 and 5 are provisions that are lex specialis, if I may use the term that was used in the case of Day. They are special because the Parliament has made specific provision in respect of them. Section 6 is also a lex specialis provision, because Section 6 tells you what is an existing law. When you put those special provisions in the context of the Constitution as a whole, you will see that Parliament has done two things. It has said, first of all, in Section 6, pre-1976 laws are saved, of which the Sedition Act is one. It's an existing law, as the case may be, and therefore 4 and 5 does not apply to it. The second thing it does, it says in post-1976 law, Sections 4 and 5 apply, and therefore you're open to judicial review on the basis of the living tree doctrine and how it has to be construed. In respect of Section 1, it should be narrowly construed and confined to the issue of a democratic state and what are the essential ingredients of a democratic state, separation of powers and rule of law being the only two identified ones. And the link in all of them is in the case of Suraj, if I may say so respectfully, because in Chandler, Lord Hodge in his judgment said clearly that it applies in respect of separation of powers, and therefore it was not argued at first instance. He did not intend to deal with it there extensively, but he expressed an opinion. The fact that Section 1 did not cover the question of accrual and unusual treatment and punishment.
Well, Mr. Hussain, we're running rather over. I think we return to Suraj at 2 o'clock, if that's all right.
Thank you very much, Millet.
Thank you.
Grateful to you.
Thank you very much.